Hi, this is Pat Moorhead with More Insights and Strategy, and we are here for another More Insights and Strategy podcast. And we are talking about one of my favorite things to talk about when it comes to innovation and patents is that's valuing the strength of patent portfolio. And it is an honor to have our guest, David Kappos, who is a partner with, I want to make sure I get this right, Cravath, Swaine Moore, and former Undersecretary of Commerce and Director of the U.S. Patent Trademark Office under one of our wonderful presidents, President Obama. Welcome to the show, David.
Yeah, thanks, Pat. Great to be here.
I want to make sure did I get your title right? Maybe reintroduce yourself. I mean, it's a great long title you have there.
Yeah, thank you. You got it just right. Yeah, so during the Obama administration, I was fortunate, very lucky to be able to run the United States Patent and Trademark Office. The title is one of the longest ones in government, Undersecretary of Commerce and Director of the United States Patent and Trademark Office. And there's some logic to it because the job is one that's got an operational component. Director of the United States Patent Office, your job is to make sure that hundreds of thousands of patent applications and hundreds of thousands of trademark applications get examined and processed each year. And then the Undersecretary of Commerce part of the job is a policy job. You're advising the President, Secretary of Commerce, and the administration on intellectual property issues. So it's a bit of a two-hat situation and a long title.
David, I love it. I am a technology analyst, worked 20 years. We're at a real job running businesses, but my family is into intellectual property too, which is cool. My dad and my brother are both in the game, but that doesn't make me the expert. You're the expert. So I want to dive in here. I'd like to dive right into standard essential patents, as we call SEPs. And, we talked about you're the director of U.S. Patent and Trademark Office under President Obama, which really gave you a global view of the patent system, not just in the United States, but globally. First off, let's start off with a definition. Can you talk about what is a standard essential patent?
Yeah, sure, Pat. So happy to do that. So to do that, let me back up just a step here. Standards are all around us. Government set standards in the United States. NIST, National Institute for Standards and Technology, sets many standards. Standards cover things including like the plugs that we have on the walls in our homes and plug so many devices into. Standards cover the distance that railroad tracks are apart from one another. Many standards are, very mundane, weights and measures kinds of standards, and radio and television standards so that devices can interoperate with one another. And they're more or less a matter of, agreeing on some distance or some particular thing, how far apart those plug prongs are going to be. And then everyone just settles it, moves on, and makes products according to the standard. But there is a second kind of standard that's become incredibly important, and I would tell you groundbreaking in terms of its ability to unleash innovation and consumer surplus, and that is innovation-driven standards. And these are standards that, sure enough, they produce specifications that describe ways that everyone is going to agree to do a certain thing, but they're not based on just making a choice like how far apart plug prongs are going to be. Instead, they're based on innovation. They're based on parties investing in research and development, creating inventions that eventually result in patents, and then getting together and choosing among the various inventive approaches that they've created to try and figure out the best, most innovative approach to solve a problem. And so those are what I refer to as technology-driven or innovation-driven standards. They're extremely expensive to create in the first place because there's so much R&D that goes into them. And they're expensive to develop because they don't just involve, agreeing on a distance for plug prongs. They involve agreeing on many, many complicated and nuanced and innovation-driven topics. So the patents that get created in the process of developing the innovation that goes into those standards, if those patents prove to be essential to the standard, in other words, the standard cannot be implemented without using such a patent, that patent is declared to be an SEP, a standard essential patent relative to the standard. So a long answer, but it's a little bit of a step-by-step, not terribly complicated, but I think you need to understand the context to get where SEPs come from.
Yeah, it is important, particularly because they are sort of the ground floor of the big innovations, and a lot of corresponding patents down the line cited. There's improvements and things like that. Now, these are very expensive, as you said, and typically, and I don't like to mush R&D together because research and development are actually two different things. Research is highly risky, doesn't always end up with something you can monetize. Development is taking a standard, then building a product that corresponds with that standard. But why do companies spend so much money creating these standard essential patents?
Well, at the end of the day, because they think they can earn a return on the investment in the innovation that eventually goes into the standard. And Pat, what I would tell you about that is that the companies who invest in the R&D know full well that they're going to be giving something up by making
Yes.
the contribution of the resulting patent to the standard. They're giving up the ability at the end of the day to exclude the entire marketplace and to keep the innovation purely for themselves. They do it, though, because the contribution of those patents to the standard creates a greater good, a good in which, to be fair, they can profit, right? Companies pursue a profit motive, and that, of course, is great. It's called our capitalist system, and it works extraordinarily well. So that's a good thing. But they also recognize that they're profiting through contribution to innovation-driven standards by helping others to profit at the same time. This is the classic example, Pat, of the rising tide lifting all the ships, right? And so the calculus that these companies are making is that by contributing their patented technology and agreeing to license it to others, they will encourage others to come into the standard. They'll create a good greater than any one of them could create individually. It will be adopted broadly and widely, and they'll all get a chance to profit. And that has proven to be the case to the wild benefit of consumers, first and foremost.
Yeah, 5G is a perfect example of that. And I'm glad you brought up the somewhat of the risk of showing all of your inventions to everybody out there into the world. You might get some benefit from it doing it, but they're not all companies share their intellectual property with everybody. Some really huge companies, in fact. So I want to talk a little bit about 5G. And it's funny, everybody wants to be number one in 5G, whether that's, hey, I'm the fastest, I got here the first, I have the widest, the highest quality, but there's also a bit of a horse race in being number one in 5G. And I know you've written extensively about this. We talked about this in the green room. Can you talk about what you know about the standards contribution process and how firms take pretty radically different approaches to contributing to the standards?
Yeah, so it's a great question, and it sounds simple, but it's actually a very broad question. So the first part of the answer is that advisedly and appropriately, the standards development organizations don't tend to set very specific rules about what patents get declared to be standard essential patents. And I say it's advisedly because we don't want our SDOs getting involved in the minutia of that stuff. Their job is to develop great standards. But what that results in is a kind of a very much a self-policing environment in which companies that are participating in creating these standards get to use their own discretion as to what they designate as being a patent that is a standard essential patent. We're not yet talking about the quality of those patents or the value of those patents, but merely the designation of them. It was very much self-propelled. Companies get to decide for themselves what they designate. And then secondly, there are, again, well-placed and appropriate incentives to what's called over-designate. And when I use those words, I put them in quotes because they might sound negative, but it's not at all meant to be negative. So let me explain that too. There's at least two factors that are moving at the same time when parties are designating patents as standard essential. One is the scope of the patent itself, because these patents are normally in prosecution, or their families are in prosecution, meaning their claims are not completely set yet. They're not like locked in stone or statues. They're actually developing. They're changing in their nature, and their claims are being refined as the standard is being developed. And that second part of it is the second parameter that's dynamic, which is the standard is being developed at the same time these designations are being made. So we've got at least dual dynamic at play. Parties are asked to make designations while the standard is moving and while their patent claims are moving. So of course, there's going to be an over-designation that occurs. And in fact, it's a good thing, and it's encouraged, because you want patents that that read on or that are essential to the standard writ large, thought about broadly, to be disclosed. Those are the ones that everyone can deal with, and they become subject to what the licensing paradigms that are available under the standards. So it's all perfectly okay, and in fact, it works fairly well. But with the designations being voluntary and the various factors that I've mentioned that are dynamically moving at the same time, it should come as no surprise that designations are broad, over designations occur, again, that's okay, and that parties with a lot of discretion will apply that discretion in different ways. So there are some that will be more circumspect and will tend to designate more carefully, and there are others who will be more expansive and will tend to designate more broadly. The end result of that, Pat, is that, my studies of this topic and my long involvement in this area, both supporting clients who are making those designations, as well as evaluating the results of them when I was in the government, are that there's not a lot that can be said about the importance or the level of aggregate contribution of any company based merely on the fact that they designated X, Y, or Z patents as being standard essential. That the quantity of designated, put it a little differently, the quantity of designations is randomly associated with the quality of the contributions. In other words, there's virtually no association at all.
That's probably the best explanation, and I actually understand it at this point. The standards and the designations are being done at the same time. So parallel paths, which, hey, parallel paths is always quicker, but it's not always the cleanest process. And I'm sure that we could do the standard, pause, and then do the designations later, but that seems a little bit inefficient. So
it's a little bit like President Obama commented just recently about democracy. It's messy. And the standard essential patents designation process is a little bit like democracy. It's messy.
Yeah, no, I love that. So, hey, let's talk about something that I get excited about. And I love the whole patent counting, patent quality debate. But can you maybe simplify what's the distinction between the two? Because some people definitely are talking about the numbers, and we see them on press releases and slides, and everybody's proud of it. And then people are like, but we've got these highest quality patents out there that made the biggest difference out there. Can you talk through that?
Yeah, so I'll try and help with that one also, Pat. And again, these are great questions, and they're all, they sound simple, but the answers to them are a bit complicated. So these standards that we're talking about, in the case of 5G, thousands of pages of technical details. Of course, not every aspect of the standard is equal to every other aspect of the standard. There are some aspects that are extremely fundamental, that require enormous amounts of R&D, and where an important invention, an invention that solves a problem related to that aspect of the standard, can be, absolutely provide a major breakthrough in the technical outcome that's achieved. So, examples that come to mind for me that I find to be both fascinating and miraculous is the switching effects that are available on 5G. I don't know if you've noticed this, but I ride on trains a lot, like Amtrak, and I notice on 5G, when my phone is showing a 5G signal and I'm on a call, the switching between cell stations is so seamless that I can't even tell I'm moving between cell stations. It's really miraculous. And then, of course, don't forget the enormous increase in bandwidth that's available on 5G. I run speed tests occasionally. I'll be, on Amtrak getting ready to go on to some Zoom meeting or something, and I'll check the bandwidth on speed test of my 5G cell signal. And it's, routinely 35, 40 meg per second download speeds. I mean, 4G, as good as it was, it's like an order of magnitude lower than that. So how do those miraculous improvements occur? Through miraculous innovation. And the innovations that go into those major parts of the standard, that produce the huge net aggregate benefits for consumers, are themselves patented. And the patents that cover those, I would argue, are extremely important to the standard, and are the patents that confer a disproportionate high value to the
Right.
standard. Now, there are other aspects to these standards that are perfectly legitimate, and they're essential to the standards, but they're much less critical. And those can be, sort of side features, optional aspects that maybe most parties won't implement, but a few parties will implement. And to be fair, there are details in these standards that really are a matter of just sort of choosing a certain approach, and any approach is as good as any. Kind of like the distance that train tracks are apart. You could have gone with 36 inches or 35 and a half, and it probably would have worked okay either way. But we had to make a choice. So there are some patents that cover those, and legitimately they're part of the standard and they may be essential, but they confer far less value to the standard, because they confer far less of the um, performance and technical benefits that consumers will value. And so the trick and the hard part in assigning importance to the patents that are declared as standard essential is sorting out, which of those features rises to the level of being, truly a key feature that confers the technical value and the consumer value, versus the others that are relatively of minor importance. And of course, there's a broad spectrum in between. So that's the issue. And that's why, Pat, I say, declaring the fact that one company declares, X, Y, or Z number of patents, it doesn't really tell you anything about the value that that company is bringing to the standard.
So I have to ask though, why does it matter that we accurately assess this? Is it about bragging rights? Are there economics involved? I mean, what if we get it wrong? I mean, is it really that big of a deal?
Yeah, it is a big deal, actually. Not just kind of a big deal. It's a very big deal. And I give you two parts to the answer on this, and they're both important in different ways. The first one is there are implications to our nation in the way we think about what's happening in America and the level of our ability to lead in technology development, and as a consequence, our sense of national security or national insecurity. So these are really important things. National security is unquestionably very, very important.
That's not kind of a big thing. That is a big deal.
It's a big thing, as well as economic prosperity and economic leadership and technological leadership. And when we glibly assume that quantity equals quality, we wind up going down a problematic and a non-factual, right, path, and then potentially coming to a conclusion that we've lost the 5G race. And declarations were made a few
Right.
years ago along those lines when it's not at all clear that we lost the 5G race, or some would say, and I would be in this group, would say we didn't lose the 5G race at all, if it's looked at appropriately. So that's one of the reasons that it matters. Getting this calculus right enables us to have an accurate self-view and view of other nations, companies X, Y, and Z, writ large, relative to contributions to any standard, and in the case of 5G, that super important standard. But the second issue, Pat, is that at the end of the day, the contributions made to these standards is an important measure that the companies use, and eventually courts use, and arbitral bodies use, and mediators use in determining who gets remunerated, how much, by whom, for their contributions. And that's also super, super important because, again, the companies that are making important R&D based contributions to these standards need to get reimbursed for them. They need to get compensated, or they simply will not be able to keep doing that, right? And so it becomes important that we get this right, and we don't just rely on quantities of patents, but we find a way to judge the quality, the net aggregate effect in the standard of the contributions of various companies, so that the gals and guys who are really contributing big value get compensated, and the gals and guys who are contributing potentially huge quantities but much lower value are getting compensated, if at all, appropriately to the actual value that they're providing, and not overcompensated. So this is, about ensuring accurate compensation that's tied to the value of the innovation that's contributed, so that we can continue to have the next level of 6G,
Right.
And reward and incent those who are making it happen.
I love the part, essentially, these are my words, not yours, the issue of over-rotating or under-rotating on something, an accurate count of where we truly are, where, oh my gosh, are we truly behind in 5G and we're losing to China, that we might over-rotate and make, make an investment or make decisions that really make zero sense. And the other one is a little bit more, I think most people can relate to, is that, it's no secret, if you don't get paid for innovating, doing that research and getting those standard essential patents, why would you continue doing them if you're not going to get paid for them? Well, you won't. And from a national security standpoint, if you look at the amount of companies doing research today in the United States versus how many were doing research 25 years ago, there's less companies doing it. Most of the industry is focused on development, not research, because they had a hard time figuring out how to monetize that research. Bell Labs is a perfect example of an institution that used to crank out research left and right and no longer exists. So yeah, it is very important to get the correct assessment of the value of a patent portfolio or a single patent that truly is a standard essential patent. It is It is very nuanced, though, and that's why there's a lot of lawyers and courts and smart patent folks involved. And you've written, and let me make sure I get this right, the most robust and sophisticated metrics used as proxies for comparing patent portfolios are still imperfect, weak, and noisy, end quote. So I have to ask, if we're not using the right ones, or the ones that we're using are still imperfect, weak, and noisy, how should we be measuring the strength of a patent portfolio?
First of all, that's a great quote. Thank you. So, so it's like a lot of other things in life, Pat. You can try using proxies and shortcuts. My mom taught me a long, long time ago that stuff frequently doesn't work, and it's the same here. The proxies I found from actually studying them are pretty lame. Like I said, the quantity proxy, you might as well use a random number generator, right? It is not related in any sensible way. And other proxies like counts against portions of the standard, extremely noisy also. What's called forward citation counting and reverse citation counting. And I don't need to go into all the gorp of this stuff, but that's using the patents, later ones and earlier ones that have cited to or are cited by the applicable patent. Those metrics are easy to game. They're also extremely noisy. Even breadth of filing, how many countries have you filed in? That metric can be gamed. Metrics like, well, have you successfully litigated the patent? May be more valid, but there's so few patents that get litigated and go to judgment that it's a metric that's got very limited applicability. So at the end of the day, what you find is that you got to do it the old-fashioned way. You need to pay an expert, and this is a pretty deep expert, because it's got to be someone who knows about patent law and patent claim interpretation on the one hand, and who knows about the standard on the other hand. You got to put those two skill sets together and get someone, and they could be assisted by AI tools, et cetera. We've got some tools that can be helpful in this day and age. But at the end of the day, it's got to be a human with those unique sets of skills, reviewing the standard against the patent and making an assessment about the importance of the innovation relative to the portion of the standard that it relates to. There isn't any machine or any AI algorithm I know of that can do that. It's got to be people.
Yeah, I mean, some things are complex and are nuanced and so important that there is no one answer for that. And I know this is very different, but I spent a lot of time on benchmarking boards of technology where people have put it together. And I think after looking at performance benchmarking in technology, you hear there are lies, and then there are benchmarks. Well, it's the same thing, but I think everybody agrees that even though the benchmarking system is flawed, we're better off at least directionally on moving in that direction. And the performance benchmarking industry takes a very similar account where the answer is it depends. I have no one answer, some magic bullet that is gonna bring this all together. So, David, I want to thank you for coming on the show. I really appreciate that.
Yeah, Pat, my pleasure, and thanks for the great questions, and thanks for studying and exploring such a challenging topic.
Absolutely, it's my pleasure, and it is a constantly moving target, particularly across administrations and then across countries in what's happening. Just fascinating things going on around the industry that have really big impacts, whether it's national security, future stability of the economy and the strength of economy. You're working on some really big stuff. So getting the message out and hopefully educating more people on the importance of how to value the strength of patent portfolios, I think is going to do everybody a lot of good. So thank you so much.
Yeah, well put, Pat, really well put.
So this is Pat Moorhead with More Insights and Strategy, signing off here. Exciting discussion about patent portfolios and valuing them. It's not just about counting. It's complicated, but it's important stuff. If you like the show, hit that subscribe button. If you've got some comments for me, you know where to find me on Twitter and LinkedIn. I spend way too much time on social media. Let me know what you thought. So let's sign off here. Have a good morning, good afternoon, good evening, wherever you are on the planet. Thanks a lot.